We are group 3 presenting on chapter 12, school desegregation.
Okay, I'm going to start by talking about de jure segregation, which is segregation that is sanctioned by law, as was the case in Brown versus Board of Education 1. Because the Equal Protection Clause essentially covers state action, it prohibits state endorsed discrimination. So Brown versus Board of Education had students in 4 separate states: Kansas, South Carolina, Virginia, and Delaware. All of these students petitioned to join white schools. All of the schools except for Kansas actually had statutes that called for segregated schools. So Kansas was kind of taken out of the discussion. They permitted it, but it wasn't a statute. And so students were able to desegregate a little bit easier in that state. However, the other states cited the Plessy versus Ferguson case to defend their side. Plessy versus Ferguson was an 1896 Supreme Court case that ruled separate but equal, stating that as long as the students had equal access to facilities and academics, they could remain separate. However, the students that were segregated argued that they were not equal because upon investigation, they did not have access to the same kinds of facilities, nor the same kind of educational opportunities, and they were being kept away from white students. So the courts ruled that separate but equal was actually impossible to achieve because colored students were still being separate and had access to different facilities, as I already said. It was actually ruled unconstitutional, and the schools were to desegregate with with diligent speed, and the transitions were handed back to the individual states to manage. And so then from there, Brown versus Board of Education 2 needed to be passed because of the implementation process, and that's where Brooke's going to take over.
All right. I messed up on your slides. I'm sorry. So after its ruling in Brown 1, the Supreme Court ruled in Brown 2 to ensure proper implementation of ruling in Brown 1. The court remanded the cases to the federal district courts because of their close proximity to the school districts. So this ruling mandated that school authorities be delegated the authority to implement its ruling in good faith and with all deliberate speed. So the ruling in Brown 2 was handed down as a means of expediting the ruling that came from Brown 1. So Brown 2 remanded desegregation cases to federal district courts because of their close proximity to the local school districts. So basically by the 1960s, the Supreme Court had realized that the test of good faith and all deliberate speed was not moving as rapidly as they had mandated. So the Supreme Court really became more aggressive by ordering immediate desegregation of students and facilities in the Rogers versus Paul case in 1965, in which a desegregation plan adopted by the school system was a grade a year plan. They ruled that where equal course offerings weren't available, Black students must be admitted immediately to the white school, which had a superior curriculum. So then the Swan case here was a leading case in defining the scope of the duty to eliminate de jure segregation in a dual school system. The objective in this case was to ensure that school authorities excluded no student of a racial minority from any school directly or indirectly based on race. They also said that the use of mathematical ratios was only a beginning point in the process of shaping a remedy for eradicating segregated schools, and that if an optional majority to minority transfer provision is implemented, transferring students must be granted free transportation. They said that the provision for optional transfer is an indispensable remedy for those students willing to transfer to other schools in order to lessen the impact on them of the state-imposed stigma of segregation. So also from that case came pairing and grouping on non-contiguous school zones, saying that it's a permissible tool and should be considered in light of the objectives sought by the school district. An objection to transportation of students may be valid when the time and distance of travel is so great as to either risk the health of children or significantly impinge on the educational process. So what the book said here was that maps really don't tell the whole story about the school zones, and that they may actually be more accessible to each other in terms of critical travel time, or good highways rather than schools that are closer geographically to each other. So they said conditions in different localities will vary so widely that no rigid rules could really be laid down to govern all of the situations.
All right, I think this is when I take over a little bit. So busing and desegregation. So you kind of touched on a little bit already, with the distance and travel idea, and I'll get into that in a second on how they kind of commingle here. But historically, the courts have viewed busing as an effective means of achieving desegregated schools. It has met opposition by parents and taxpayers who considered busing to be a threat to the neighborhood school concept, time consuming for students, and an added expense on taxpayers. So this is just saying, so as a parent for desegregation, to make sure that the school is desegregated and it wasn't affecting just the neighborhood, schools were worried about if neighborhoods were predominantly, say, African American, that school was going to be predominantly African American as well. So what desegregation with busing was doing is essentially taking African American students in a certain neighborhood, maybe busing them to a different school that might be more predominantly white. And that's when the taxpayers are starting to come up with the idea that this might not be a well use of the money going into transportation. So parents and taxpayers advocated that money be expended on improving neighborhoods, schools, rather than busing, which makes sense for certain areas. And you see this especially in like bigger cities. California, for example, was one of the leading ones. For example, several states passed anti-busing legislation to prohibit the use of busing. Like I said, when you start looking at those bigger like city areas with multiple schools and those predominantly certain race areas, making sure that schools just weren't predominantly Black, and they were looking at more of this desegregation idea for schools as well. And a number of district courts concluded that allowing students to attend schools near where they lived would not effectively discriminate dual school systems. So again, that's kind of what I was saying earlier. Busing is considered one viable measures used by courts to achieve desegregated schools. And then we got de facto segregation. And this is kind of the same idea. De facto segregation is present when a substantial number of students enrolled in a school represent racial and ethnic minority. This kind of feeds into that busing desegregation. This situation developed through action taken by the school district. If you guys think about this, like in medieval England, people were customarily segregated by social class or status. This is kind of the same idea when you think of 1950s, 1960s in the US when we are segregating because of race or even status. Let's see. The courts did, however, mandate that corrective action be taken in instances where school officials gerrymandered or altered school attendance zones to create zones with large contractions of Black students assigned to historically Black schools within the district. And this is just saying that you can't make certain school zones based on just race. And that's more of a federal thing. And that's essentially why states were going against that busing desegregation idea.
All right, and I'm going to continue on this. So this is stating district courts may alter attendance zones and may devise zones based on grouping and pairing schools and may require busing to achieve desegregation. And then district courts may disallow patterns of school construction and abandonment that create a dual system of education. And so kind of the overarching theme here is understanding that school districts generally are not required to take corrective action in cases where racial imbalances have developed within the schools of the district as a result of housing patterns and the uniform application of school zoning and student transfer policies. However, that does not mean that the courts will support unequal facilities, programs, and staffs in predominantly Black schools. So school districts just have to be careful when rezoning areas so that they are not rezoning so that the schools become predominantly one race or another. And then going on to the next slide, stating plans devised that result in substantially segregated schools are illegal. So there were some cases where school districts were kind of trying to, secretly, I guess you would say, rezone the schools so that it kind of would still be segregated, but it looked like it wasn't. And so that was obviously, the courts did not agree with that. And then because of some of this desegregation happening through trying to bus students and things like that, there was a time where there, I don't know what to call it, but where white flight happened. So students were allowed to go to more predominantly white schools, while when rezoning happened or busing happened, a lot of the white students chose, or the families chose, to move out of those districts. And so it kind of caused some disruption there where, again, it became unequal for the students who were choosing to attend those schools. And we can go on to seeking unitary status. So school districts across the nation have filed for unitary status. So basically what this means is that school officials claim that in good faith efforts, have been initiated to achieve desegregated schools. So therefore they should be relieved of court supervision. So there are some states that have received that. However, there are some states that have applied for that and have not received that. And so going on to the next slide, a good faith incremental approach to achieving unitary status is acceptable by the courts and considered to be constitutional. And so there was an instance where a school district applied for this unitary status because they felt like they had reached that point of desegregation in their schools. There's kind of a checklist of different things that have to be in place, and the school district did not meet all of those. They met like 4 out of the 5. And so one court ruled that they were okay and they could seek unitary status, but then it was overruled by another court, which said they can have unitary status in the 4 areas that they reached it, but they still need to be working on the last area where they haven't quite achieved that desegregation. And so yep, and we can go on to the last slide. So through relinquishing control in areas deemed to be unitary, a school district may effectively focus on the areas in need of further attention. So basically what the court ruling stated was that you don't have to sit in unitary status with all of those areas because you already met it, and we don't want you to put your time, effort, and money into those areas. Take your resources and put them into the areas where you aren't desegregated, and so you can reach full unitary status. And that is it for that.
All right. Anybody have anything you want to add before we close? All right. Thank you.